This is Politics and Media 101. I'm Jeff Browning. Barbara McQuade is a former prosecutor who has studied and participated in the judicial system for decades. She has a very unique perspective on this moment in history, on what does and doesn't work well about our law enforcement and court systems, and how these problems are likely to evolve in the future. Please take a second to subscribe on whichever podcast streaming service you're using right now so you don't miss our next episode this Wednesday, which will feature Congresswoman Sarah Jacobs from California. We'll get into it in just a second, but first, a message from Justin.
Hey, Politics and Media 101 listeners. We want to tell you about Future Hindsight, an award-winning podcast that takes big ideas about civic life and democracy and turns them into action items for you and me. In this midterm year, they'll bring you conversations that can truly support your decision-making beyond the horse race. Join host Mila Atmos every Thursday for in-depth conversations with citizen changemakers about how they're building their civic action toolkits. You'll learn something new and come away with hope and inspiration to bolster our democracy. Follow Future Hindsight wherever you listen to podcasts or tune in on futurehindsight.com.
Without any further ado, let's roll the tape.
Can you explain your understanding of how direct or indirect of a role Merrick Garland is taking in prosecutorial decisions of politically related matters? And do they compare to the micromanaging that William Barr did?
If there is to be a very significant case, I would expect that he would be briefed on that case and would approve that case. So, for example, if anyone were going to charge high-level government officials relating to conduct around January 6th, he would absolutely be involved in that. The criticism, I think, that was directed at William Barr, micromanaging is a good word. In the case of Roger Stone, the prosecutors had already filed a sentencing memo, and then William Barr came back and directed them to ask for something less than the sentencing guidelines. Same with the Michael Flynn case. He had already entered a guilty plea to false statements to the FBI, and then William Barr directed that they dismiss that indictment. And so those struck me as kind of after the fact, meddling after decisions had already been made. But when I was in the Justice Department, I remember there were a few cases that were very high profile. And one of the things I was told is there are certain cases, very few of them, but a handful of cases that are so significant and have such national implications and even international implications that they belong to the Attorney General.
Trust in the DOJ was really eroded under William Barr. I can't remember a time in my life, I'm 33, where the media focused so much on a former or a sitting attorney general and his actions. So you have low trust, then you have these cases where you might be prosecuting your political opponents. Does this require a greater burden of proof than your normal run-of-the-mill case at the DOJ?
There are two questions that prosecutors have to answer before they file charges. One is whether they have evidence sufficient to obtain and sustain a conviction. But then you're not done. There's one more question that has to be answered, and that is, even if we can charge this case, should we charge this case? And the question in the Justice Department manual is, will it advance a substantial federal interest? And that's sometimes referred to as the should we charge prong. Okay, we can, but now the question is, should we? You don't charge every case just because you can. There is prosecutorial discretion. Sometimes cases are so minor that you let them go. They just aren't worth the resources. Sometimes you're concerned that it would appear heavy-handed or just doesn't seem fair. So there are a lot of reasons that prosecutors decline prosecution. But I think in the case of a former president, there are some really important considerations to be made. One is, I think we don't really want to be the kind of country where a president is prosecuted on a frequent basis by his successor. That has the feel of a banana republic that we would like to avoid. On the other hand, if a president engages in such egregious conduct as to put democracy in peril, then I think an attorney general has to think that there is a substantial federal interest to hold someone accountable to deter future leaders from engaging in similar conduct. And so I think the first thing that would happen in an examination of what happened on January 6th is the can we charge prong? Are there crimes that appear to have been committed? And then the much harder decision is that should we charge prong in light of the fact that we have this evidence. And I also think that, while no one is above the law and everybody should be treated the same, I have to imagine that when you're thinking about charging somebody at the level of a former president, you can't help but think in the back of your mind that old adage that if you come at the king, you best not miss. Because if you were to charge a Donald Trump and then lose, I think that would open the department to allegations of partisan politics and lack of independence and other kinds of things that could be really damaging. And I think one of the things that Merrick Garland has made very clear is he sees his top mission as restoring trust and independence at the Department of Justice.
The defenders of the January 6th terrorists were crying from the hilltops that nobody had been charged for seditious conspiracy. But finally, the Oath Keepers founder, Stewart Rhodes, was charged with seditious conspiracy. For us in the audience and not in the legal profession, how serious of a charge is seditious conspiracy? And have you ever had to charge anyone with seditious conspiracy?
It is a serious charge. It is one that is alleged rarely. The gist of the charge is that two or more people conspired to use force to combat the authority of the United States. On that day, our government was at work endeavoring to facilitate the peaceful transfer of power, and they physically tried to stop that. So it seems like a really perfectly appropriate charge in that instance. It is rare, but that seems like the kind of place where you would use it. I have used it once in a case about 12 years ago. We had a case involving a militia group in Michigan that was training and plotting to kill police officers because they wanted to start a battle with law enforcement, state and federal law enforcement, to start a civil war. We lost that case. The judge dismissed the case at trial before it got to the jury. I think in the 12 years that have passed since that time, members of the public have gained a better understanding of the risk that is posed by militia groups. And so what seemed like an unbelievable fantasy 12 years ago, based on what we saw on January 6th, makes that a lot more tangible and easier to understand what a real risk this is. I think because of cases like mine that failed, people tend to think that this is a weak charge. I think it is a strong charge for the right case, and I think this is the right case. There they were at the Capitol, the People's House, the seat of our government, fighting against U.S. Capitol police officers to stop the peaceful transfer of power. It's pretty clear what their plot was, that it was to stop that vote from occurring because they wanted to stop Joe Biden from being certified as president. So I think it's a strong charge as long as they have the evidence that they say they have.
So in those 48 pages, do we learn anything about any potential connection that Stewart Rhodes had with the white collar, quote unquote, criminals during this insurrection, people like Rudy Giuliani and Mark Meadows who were in the White House? Is there any connection between the Oath Keepers and larger figures that were more senior in the Trump world?
Yeah, not on its face. And so, in fact, at one point, it appears that they expected to get the call, the order from Donald Trump that they had been activated as a militia and that he had declared under the Insurrection Act, he had activated the militia to fight back against enemies of the United States. It's kind of a fantasy. Was there a coordination between this attack and the larger plot, which is starting to come into focus now? The idea was that Mike Pence, when he's there counting the votes, Mike Pence would open these certificates and see, oh, well, in these 6 or 7 swing states, I've got 2 sets of electors. So I guess I just have to throw those out. And then if you eliminate those states from the tabulation and you add up what's left, Trump wins. And if people object to that, he's got a fallback plan, which is to say, well, I guess by the Constitution, we throw this into the House of Representatives, where we know that the Republicans have a majority. That plot seems to be taking on some clarity now. And so if part of that plot was to make sure there was chaos so that they could not certify a winner, maybe that was also part of this plot. And I think that connection between Roger Stone and this member of the Oath Keepers might be some fertile ground for determining whether that happened.
Hi, Barb. I want to follow up on something that you just referenced, which was the false slates of electors that were submitted to the U.S. government. And I'm the family member of a former U.S. attorney, and he specialized in white-collar cases, especially wire fraud and mail fraud. And I looked at the facts of this situation, that these GOP operatives created these documents claiming to be the Electoral College electors for these key states, knowing that they weren't the legitimate ones, and mailed them to key offices in the U.S. government. And it seems to me that maybe this situation has the components of a mail fraud case. And I wanted to know if you agree, if you think that it's possible that we might see a prosecution of mail fraud in this situation.
Mail fraud is a crime, but so many crimes come down to what intent you can prove. So, did they intend to defraud the recipients in Washington, the Senate, and the National Archives, and participate in this scheme to create chaos on the Senate floor on the day these were being counted during the joint session? If so, then yes, they could be considered part of a scheme to defraud. However, I think there's also a possibility that they may say they were just submitting what's known as a provisional ballot. We thought there was a lot of uncertainty and irregularity going on with the election in Michigan. We believe these people who told us that the election had been stolen, and we knew the deadline for casting the votes of the Electoral College was December 14th. And so even though it hadn't been sorted out yet, we thought we better sign our names to this thing just so we don't miss the deadline. I think what's emerging now is that there was a member of the Trump campaign who directed them to submit this slate of electors. I think the intent will matter a lot in determining whether these folks are criminals or whether they are just pawns.
So this is, of course, an issue that the January 6th Congressional Committee are looking at very closely. They've subpoenaed a number of the key figures that are involved in this scheme to send the alternate slates of electors claiming to be the legitimate Electoral College electors.
Yes.
What I'm curious to know from your perspective is how close the Congressional Committee and the DOJ are really working together here. So do you think that the DOJ are looking very closely at these kinds of actions, that they're keeping a close eye on how the investigation at the congressional level is unfolding and whether the kind of revelations that might come from further investigation to this point might lead to indictments?
It is not permissible for the Justice Department to share with anyone, including members of Congress, material that occurs before a grand jury. I am sure that they will be very happy to receive anything that the Congressional Committee wants to give to them. So I don't know if they are telling Congress what to do, but I imagine they are watching carefully. The one area where I think it would be really important for them to coordinate is we're starting to hear some discussion about granting immunity to certain witnesses by the committee. And I would hope that the committee members are saying to DOJ, hey, DOJ, we're thinking about granting immunity to, say, John Eastman or, Rudy Giuliani, I don't know, whoever it is. Do you have a problem with that? Before you grant someone immunity, you better make sure that they are not a significant wrongdoer in the plot that might be under investigation. So, people like John Eastman and Rudy Giuliani, if you want to give them immunity, there could be some serious consequences down the road for DOJ. So for that reason, I hope they're at least coordinating strategy at some level.
I'm curious to hear from you, as someone who's followed this investigation very closely, what you think the committee is hoping to find out specifically from Mr. Giuliani and where his testimony might lead them.
I think that it's tempting to be dismissive of Rudy Giuliani as a crackpot whose best days are behind him. But I also think it's important to remember who he was. He was a U.S. attorney during the 80s who prosecuted the mob, brought some big mafia cases, public corruption cases, insider trading cases. So he understands how this works and how the cooperation game works. He is also in some serious trouble. DOJ, the Southern District of New York U.S. Attorney's Office, executed a search warrant against him. They seized 18 of his electronic devices and are still reviewing those for evidence. And he faces potential criminal charges there. This could be his best opportunity to get out from under that. And I know, there are people who say, well, he's loyal to Trump and in no way does he, change sides and cooperate here. There is no loyalty among criminals. I have seen this many times. We saw this with Michael Cohen, Trump's lawyer, who swore he'd never cooperate against Donald Trump, who absolutely flipped 100%, has written books about it, has a podcast about it now. So I think that there's absolutely every possibility that Rudy Giuliani could do the same. Your other question, I think, is a good one, which is someone whose credibility is so deeply tarnished, could he in any way be a credible witness? And I think, again, the answer is yes. Giuliani himself has flipped mobsters. Sammy the Bull Gravano was still able to testify against other members of the mob. And the way you do that is you have to corroborate everything they tell you. It may be that you don't put him on the stand and ask a jury to believe him, but you have him tell you behind the scenes, what documents can you share with me? You were at this meeting. Okay, who else was there that we can put on the stand? Who will be a credible witness? Oh, General Kellogg was there. He seems credible. We'll have him testify about it instead of you. What documents can you show us? Phone records, text messages that can corroborate what you're saying. And maybe we don't need you to testify at all. We'll just use these documents to tell the story. So I think he could provide a lot of value if he wanted to.
We are going to go next to Jason, and after Jason, we are going to go to Shanette. So over to Jason first.
So I really have a two-part question. I think the first part of the question might be harder than the latter. The first is, all the smart money would say that you are probably on the short list for a judicial appointment. So my question would be, is that something that you would be interested in, considering all the work that you're doing, on networks and the commentary that you're giving? But the second part of the question would really be, and it's more for the larger audience, if you could kind of explain the benefits of bringing federal hate crimes charges against individuals who have already been convicted of state level, let's say, murder charges. The most recent example I'll give is the trial of Gregory McMichaels, Travis McMichaels, and William Brody Bryant. What is the benefit there? They've already been convicted and they are going to serve life terms in prison.
Yep. Great questions. Number one, no, I do not want to be a judge. Most lawyers do. It's a wonderful job. It's an important job. You can have incredible impact there. But I have never wanted to be a judge. I think I don't have the right temperament for it. To be a judge, you need to be an excellent listener. Much of what you do is listen. It is also a very cloistered job. After you listen, you then retire to your chambers and you spend a lot of time reading cases and writing opinions. And the work is incredibly important and impactful. But I don't think that it is something I am suited to. I'm a rather restless person. I like to talk. I like to have a thousand balls in the air. I really love being in the executive branch. I think that's a better fit for me. It is a lofty and highly respected position, and I'm really glad there are a lot of highly qualified people who want to do that. But I think that it's not for everybody, and I think it's not for me. As for your other question, great question. The McMichaels and Roddy Bryant are going to serve life in prison. So what's the point of bringing this federal hate crimes case? And I think there are two. One is the very pragmatic one, which is there's always the possibility that their convictions in Georgia could be reversed on appeal. And then they're off and home free after committing this really atrocious crime. So that's one reason. The other is that the federal prosecution is really vindicating a very different harm. The federal government is a separate sovereign from each of the states. And so in Georgia, there was a state interest in vindicating the murder of one of its citizens. In Georgia, the people of Georgia were harmed when one of their citizens was killed in cold blood, the way Ahmaud Arbery was. And so that harm has been vindicated through that prosecution. But that prosecution, although it was certainly motivated by race, really was not about race. It was simply a murder case. The federal case, which is now brought on behalf of the United States, all of us, all of the people of the United States, is about race. He was targeted. His civil rights were violated. His rights to be on a street in the United States of America were violated because they went after him because of his race. You probably remember that testimony that came up in the trial. 911, what's your emergency? Answer, there's a black man running down the street. I think that that is a key piece of evidence in this case as well. And so when someone has their rights denied because of the color of their skin, it is a violation of civil rights of all of us. And so that interest in that hate crime makes not just an individual life more dangerous, it harms all of us, certainly all the members of the same race as the victim, but really every race. If someone can be targeted based on their race, it means that we don't live in this kind of multicultural, pluralistic society where everyone has a right to be. And so it's a very different harm that is being vindicated in this federal trial.
My customary policy is to try and get all the facts and to consider the opinions of my countrymen and to take counsel with my most valued friends. The Constitution is the supreme law of our land. Only the laws of God, which govern our consciences, are superior to it. But it is common knowledge that serious allegations and accusations hang like a sword over our former president's head. Now, therefore, I, Gerald R. Ford, President of the United States, have granted, and by these presents do grant, a full, free, and absolute pardon unto Richard Nixon for all offenses which he has committed or may have committed from July 20, 1969 through August 9, 1974.
We're going to go to Shanette next. So, Shanette, over to you.
Thank you so much. And Barb, thank you. This has been amazing. I want to pick up on the perception of fairness, whether or not there could be charges filed against Trump ultimately, and why, Merrick Garland might want to be looking at, can we charge and should we charge? And you had talked about trust and independence could be restored, but be challenged, I guess, if you look like you're just going after the next guy. But couldn't it also have the opposite effect? If you don't bring charges when you can, does it look like there isn't actually fairness when it comes to people who have elected office? So that would be my question. Thanks.
I've been thinking a lot lately about Watergate and the effect of pardoning Richard Nixon and what effect that may have had on Donald Trump. One of the reasons we prosecute people criminally is to deter other people from engaging in similar behavior. And so what's the message from Richard Nixon? Well, he lost the presidency, but he kind of got away with it, right? He never went to prison. He never got prosecuted. And so if you don't prosecute people and hold them accountable, it really does kind of send a message that, hey, go for it. You might get away with it. And even if you don't, you're not going to go to prison for it. So you might as well give it a try. So I agree with you that if there is wrongdoing, so the can we charge portion, if that can be satisfied, then the should we charge question is a pretty hard one because, the easiest thing in the world to do would be to say, well, the most important thing here is restoration of trust, and we don't want to create this precedent where presidents get charged by their successors' administration. So we'll just leave well enough alone because that is just explosive, and it would be very damaging and divisive for the country. And so we don't want to do that. I agree with you that I think that if the evidence is sufficient to bring charges, especially here, imagine a scenario where you say Donald Trump absolutely knew he didn't win this election and he plotted to overturn it so that he could hold on to power, cling to power that did not belong to him, to overturn a free and fair election. That's about the most egregious crime I can imagine a president committing. And so to say he gets a pass, I think would also be an egregious mistake. So the Attorney General is entrusted with some really, really important and difficult decisions here. But I think you can't allow your very worthy goal of restoring trust and independence to completely overshadow your equally important goal of holding wrongdoers accountable.
We are going to go next to Jim. So over to you, Jim.
Thanks, John. And this is a perfect timing because I kind of consider my question a part two to this discussion, especially philosophically. We're at a point where you have kind of this legal cognitive dissonance around the fact that you have, 14 states that have in some fashion legalized marijuana, where at the federal level, it still remains a Schedule I narcotic. And I sometimes get caught up in that, regardless of my personal support, around just the issue that, the law is the law, and the basis for our country is around support for the law and to prosecute wrongdoers. And how does the professional prosecutorial corps of the Department of Justice across the country kind of reconcile with that issue that you have what still has historically remained a major break of federal law, but at the state level is more and more accepted?
It's kind of a mess for a prosecutor. I was a prosecutor in the Eastern District of Michigan in a time when we permitted medical marijuana. We now permit also recreational marijuana. The Deputy Attorney General at the time, Jim Cole, issued something known as the Cole Memo, and it said, ordinarily, if you are a federal prosecutor in a state that has legalized marijuana, even if it's medically legalized, as long as people are complying with their state regime, you should let it go. We just don't have a substantial federal interest in prosecuting somebody who's complying with their state law. So ordinarily, we weren't prosecuting those kinds of cases. There were, however, some exceptions. I think about 7 instances where you might charge one of these cases. One involved growing marijuana on federal lands, and there actually is a lot of that, especially out west. You've got these Bureau of Land Management, huge grazing areas and things like that, and so you could have acres and acres where they're growing it. That could be prosecuted. Where states that border states that don't have legalized marijuana are exploiting the law in their state. So, for example, Ohio is a state that doesn't have legalized marijuana. If you've got a grow operation in Michigan, and you're taking it across the border to send it into Ohio, that could be a basis for it. People who are involved in cartels or gangs that are affiliated with violence was another basis. So it was pretty selective. The really tricky part is that the banking system, is governed by federal laws. And so people who are in the business of marijuana dispensaries and other kinds of things who are making a lot of money can't use the banking system for their profits and their proceeds, which is really challenging because what do you do with all that cash? Now you're very vulnerable to armed robbery. So I think at some point, something has to give. I think eventually we're going to get there. It's just a matter of how slowly. But in the meantime, there are some of these places where it is messy, difficult, challenging because of those differences.
Public trust in the police is one of the most vital elements in a civilized society. But for many Americans, that trust has been undermined by a procedure called civil forfeiture.
Civil asset forfeiture is really a mechanism by which the state and federal government can seize people's property without having to convict them of a crime. Most people can't afford to hire a lawyer to challenge it. It's really legalized robbery by law enforcement.
And think about it, that is a tough crime to report to the police. Give me a description of what the guy looked like. Well, to be honest, he looked a lot like the guy currently asking me what the guy looked like.
We will go to our last question, Megan.
I'd be really interested to hear your perspective on the utility of civil asset forfeiture and what reforms you think might be necessary to prevent people who have not broken any laws from having their life savings confiscated or their property, stuck in a loop where the government has hold of it and they have no recourse to get it back.
Yeah, so this is a great question. And for those who don't know, civil asset forfeiture is if you believe there's probable cause that money or other assets are the proceeds of criminal activity. If you can simply do that, you can seize it. I don't think I would completely eliminate civil asset forfeiture because most often in the cases that we brought, say a big tax case or a big money laundering case, you had very substantial evidence that assets were being used for an improper purpose. And the alternative would be, if you want us to make a criminal case, we will. Or you can just let us proceed and we'll just take your money. And sometimes that was a good middle ground for certain kinds of cases. It was less resource intensive. The place where I think it's most problematic is when the federal government adopts state asset forfeiture. And that lends itself to this whole idea of kind of bounty hunting. You would see these cases where police departments would set up on highways across the United States on the theory that this is a route likely used by drug dealers. So if we pull people over for some very minor infraction, and, if you follow someone long enough, most people do commit some kind of minor infraction, like they exceed the speed limit by a bit, or they cross the center line when they're going around a curve, they fail to signal, they fail to come to a complete stop. Stopping somebody searching their vehicle, finding a lot of unexplained cash. Sometimes it is the proceeds of a crime. Sometimes it's, it was my life savings and I was driving to another state to go put it in a bank or whatever it is. And taking the money, people, rather than contest the charges, will just let it go because they are worried about some sort of criminal prosecution following it. And the police departments involved in these things get to keep a portion of it. It's kind of a profit sharing. We call it equitable sharing. So the police department would refer this to the federal government. The federal government would initiate civil asset forfeiture case, would take the money, and then some of it would trickle back to the police department. So it incentivized these local police departments to be very aggressive in their enforcement of civil asset forfeiture. They would take cars and houses and money and other kinds of things. And I think that just creates dangerous incentives. And so maybe a reform would be that you don't get this equitable sharing idea, that you can enforce the law, but we in my former office stopped taking these federal adoptions. I think that became DOJ policy actually across the board. I don't think it was just us. I think it was all over the country. I don't know the current status. I think it's been restored now that the feds were doing that, at least in the Trump administration. I'm not sure how the Biden administration is handling those things. But I agree with you that it's problematic in that you're taking people's money as the proceeds of crime, but utilizing it in such a way that you only have to prove preponderance of the evidence. So it's a little bit of a backdoor way of getting a lower burden of proof for allegedly criminal behavior. So I think reform is definitely appropriate there.
And to link it to the topic at the top of the discussion today, I think that the civil asset forfeiture from Paul Manafort covered the entire cost of the special counsel investigation. Isn't that right?
Yeah, and so that's why, forfeiture is not a bad thing. It is disgorging ill-gotten gain from criminals. It's the civil asset forfeiture that can sometimes be challenging. Criminal asset forfeiture does require proof of guilt beyond a reasonable doubt. You'll notice most indictments include a forfeiture allegation, and that typically says, we're going to seek all of the proceeds that this person made as a result of this crime. So in a fraud case, we're going to take all that money, and it might be in somebody's house, or they might have expensive cars or a boat, and we're going to take all that stuff. And then the U.S. Marshals will sell that at auction, and those proceeds can be sometimes restored to victims or sometimes go to the U.S. Treasury, as you said, and sometimes can offset the cost of a special investigation.
So I want to ask you if you have anything you'd like to leave us with this evening, whether it's positive or negative, any final thoughts to share before we wrap up the discussion.
Yeah, I guess I would just like to add on, and thank you so much for having me. This has been really fun, and it's just so gratifying to hear people engaged in the legal and current event issues of the day. You guys are clearly paying very close attention to what's happening, and that is so inspiring to me. I would just say that, don't lose hope. I think that there is a tendency to, think that, man, our government is just broken, and I don't have any faith in the criminal justice system, and it's so unfair, and it's so awful. Remember that our country has gone through really difficult times before, and the only thing that has made us better is good people working hard to bend that arc toward justice. So I hope you'll all continue to stay engaged and continue to work to do things that matter. It's what gave women the right to vote and what pushed the civil rights movement to, pass voting rights legislation. All of those important things only came with struggle of people who worked to make it better. So, we are a country always trying to become a more perfect union. Sometimes we take 2 steps forward and 1 step back. I think over the past several years, we've taken more than 1 step back. But, the pendulum eventually swings back, but only if we push it. So I hope all of you will continue to push that pendulum in the right direction toward justice and a more inclusive America.
That's all we have for you today. Again, huge thanks to Barbara McQuade for coming out, to our audience for their questions, and to you for being here. Like all of our episodes, this was edited down from a much longer live conversation. Anyone who wants to can join to ask our guests a question. For information on how to join us live, past episodes, and our very special email newsletter, which will deliver our best of to your inbox twice per month, please visit our website, pm101.live. This has been Politics and Media 101, produced in partnership with Clubhouse. I'm Jeff Browning on behalf of Justin Higgins, our co-founder, and our team. Thank you very much for being here. We hope to see you and hear from you soon.